Welcome to the Vegas Law Podcast, hosted by renowned Las Vegas attorney Tony Sgro. This episode is sponsored by the law firm of Sgro & Roger. Each episode explores legal insights and local stories that matter to you. Now on with the show.
Hi, and welcome to the Vegas Law Podcast. My name is Tony Sgro, and I'm sitting here with Darrell Harris. Thanks for joining us today.
And we're coming to you live from the office, so if you hear a conversation in the background or something like that, very busy legal office that we're in. So
that's right.
Today, I think we're going to talk about true crime TV and true crime TV versus reality, which is, and actually true crime is really one of the most popular genres globally.
Yeah, there's no doubt about it. It's evolved to a place where one of the stock questions now that is in virtually every jury questionnaire is, what is your favorite true crime drama show? Not even whether you watch them or not, because it's gotten to the place where jurors are watching these things, and it creates this artificial expectation, really, with what the trial's going to show and how it's going to go and that sort of thing.
Yeah, and we talked before a little bit about picking juries and the challenge that true crime TV and those kind of shows really present themselves to, because people have a kind of a preconception of how jury trials go, which may be a little bit true, but there's a lot of actual reality facts that they don't really always enter into. Can you talk a little bit about that?
Yeah, absolutely. So it's really on both sides of the fence, too. So in cases where there is a lot of science, right, DNA was left at the scene, or there's fingerprint evidence, that sort of thing, from the prosecution side and from the defense side, there's always this struggle, because when you see something on television, there is this level of perfection that is imputed into the science. In other words, once it happens, once the result comes through, it must be so. And that's just not how it is in real life. The other thing is that people don't realize is that many of the sciences that we had some years ago have faded away over time because they're not reliable anymore. And we've learned that as technology advances and makes certain science stronger, there are other technologies that have advanced that show us now that what we thought once was true is not the case. So, for example, and this is a problem that we face all the time. So there is a show called Forensic Files. Forensic Files talks about how the science in the case helped to solve a case, and typically they're homicide cases. So let's take a Forensic Files episode that I saw some time ago, and it was about bite mark evidence. Okay, let's talk about bite mark evidence just for a second. In 2016, President Obama commissioned a group of scientists, I think there were over 200 of them, to collaborate and really tear apart the aspect of what science should be admissible and what shouldn't be admissible, validate the ones that were good, discourage certain ones from being able to be used in the courtroom. When it came to bite mark evidence, the scientists were unanimous that bite mark evidence should never be introduced into a courtroom ever again, because it is inherently unreliable. And the things that they look for in teeth patterns and this and that cannot be used to objectively identify anybody. And it's basically, anyone with a set of eyes could be a bite mark expert. So when anyone can do it, that means you can't be an expert in it. And what I mean by that is this. The way it used to go was, well, I'm looking at this set of teeth marks. I'm looking at the defendant's teeth marks. Man, they sure look similar, so it must have been that person. That science in totality was rejected in 2016. However, if you watch the right episode of Forensic Files, and I'm not a fan of the show.
Come on, Tony.
But I watch shows like this because I need to understand what I'm up against when I'm talking to a jury. There are Forensic File shows that still air on television how these crazy circumstantial evidence cases were all put together at the end by bite mark evidence. So from the defense perspective, we struggle with this notion that there are these sciences out there that are still viable, still out there and still working when in fact they've been rejected. Now we're going on our 10-year anniversary. Another one is, when they talk about comparing a carpet sample, fabric sample. These are things that now have all been categorically rejected. And think about the folks that have been convicted by using what we now understand to be invalid science. So it's one of those things, like from the defense perspective, we need to cause the jurors to understand that just because someone slaps the label of science on it, it doesn't necessarily mean that it's so. It still must be examined. And I use the analogy all the time. There was a time when cigarette manufacturing companies sent people to Congress while they were smoking a cigarette at the hearings, talking about how cigarette smoking really is healthy for you, actually, and forget about it being unhealthy. It actually has the opposite effect. So science is obviously something that can be manipulated to the benefit of the one seeking to bolster an opinion through its use. So from our side, it's one of those things where we need to be able to have a conversation with the jurors to alert them that just because you put this label doesn't necessarily mean you need to adopt it as true. And then the other side of that spectrum are shows that I've heard of, because prosecutors speak of them all the time. And they have, for example, there was a true crime show where someone was shot and killed on a TV show, and the scientists were able to go and do some testing, and in the eyeballs of the person, they were able to retrieve an image, which was the last thing the person saw, which was the killer, right? Clearly that doesn't exist. That was done for entertainment purposes only. And so the same way I have a concern that jurors are going to assume that something is necessarily valid, the prosecutors have a concern that somehow there's going to be some bit of science that they should have, which is make-believe. So it really does cut both ways. And, we joke about DNA. DNA seems to be the champion of that which is good.
It's the big buzzword, of course.
Yeah, and I say do not assume. The prosecutor says do not acquit, right, when we have DNA evidence. So that seems to be the one piece of science that, if it is done correctly, and that's a big if, right, because human beings are the ones administering the tests. But if it's done correctly, there is some agreement, general consensus, that sort of science actually is a legitimate science. Fingerprints is on the table of maybe being cut off. Firearms exams, what they call tool mark evidence, was heavily criticized in the PCAST report. They still use it. They obviously still use fingerprint evidence, but those are the next two that are potentially on the chopping block.
Well, and you find that, I'm sure you find this, that once it's out in the public, it's really hard to walk back what things are supposedly assumed as established fact. Like DNA obviously has been basically proven to be very reliable, but it's humans are administering it. Humans are fallible. Humans make mistakes. In terms of criminal law, specifically like murder investigations, it seems like a lot of the true crime shows really focus heavily on that. Is that something you come up against when you're at trial?
There's no doubt about it. And the vast majority, if not everyone on the jury, most of the jurors that we speak with are regular viewers of true crime sort of TV. And the thing that gets lost sometimes is that they might be watching a true crime show based on a case that happened, 20 years ago. Man, in 20 years, just think of what your phone looks like today versus what your phone looked like 20 years ago. The phone, we joke around about the brick that existed when it first came out 25, 30 years ago. Now it's, something that fits in your pocket. When it first came out, you could call and receive calls. Today, it's your mobile office, right? Emails and the internet, obviously. All the things you can do on that one device have exponentially gotten more and more sophisticated over the last 20 years. So it's not a lot to say that if you watched a show about how science was applied 20 years ago, even though you just saw it on Netflix or Amazon Prime, or whatever your streaming platform is, there's a high likelihood that what you just saw on television is no longer supported by the scientific community. And that's a really tough place to be when you're explaining, the ins and outs of what the science might be in the case. And there's this false equivalency created that, well, if they just showed it, it must still be the standard. And that's just that it is, after all, a program designed to entertain the viewer. It is not a program necessarily aimed at strictly educating the viewer. And that distinction and that nuance gets lost.
Yeah, and they'll take certain facts and in the course of the case may not be necessarily huge points, and they'll exasperate those and really blow those out of proportion sometimes just to get the reaction of the audience. And we've seen that a lot. And I also think of shows like Unsolved Mysteries. You were seeing reruns that were literally shown 30 years ago. So has that been a real challenge for you dealing with that?
Yeah. So, you have to know the playing field, right? You have to know what you're dealing with when you start speaking with the jury. So we try to do as much as we can in the jury selection process to really vet that out. So it begins with a questionnaire. The jurors will articulate on the questionnaire which shows they watch, how often they watch them. And some of them are casual watchers. They'll watch something once every few months if it's on TV. Some jurors, though, like most, everyone's different. And some folks watch those shows all the time. Discovery ID is another one that comes up a lot. And when you're looking at that, you must then understand that you have that segment of your jury population that you must speak to about how science works, the pros and the cons of relying too much on it or too little on it. And you have experts that come in and try to explain it. And there is very little that can come into a case where for every opinion of expert A, expert B doesn't have a contrary view, which in and of itself begs the question as to how much one can rely on, quote unquote, the science of what is being offered. So that in fingerprint evidence, for example, there's a famous case, a guy named Brandon Mayfield. Brandon Mayfield is a guy who was, at the time of the case, he was a lawyer practicing in Seattle, Washington. At the same time that he's practicing law in Seattle, a bomb goes off in a train in Europe. The examiners there look at the evidence and they find some packaging from the bomb, and they conclude that this lawyer in Seattle was the one whose fingerprint was on the packaging of the bomb. They swoop down, they arrest him. Turns out, and it's been a minute, but it turns out I think he was in court that day, that the explosion occurred, et cetera, et cetera. The long story short is he would be eventually cleared. But it is the seminal example of how two persons' fingerprints can be mistaken one for the other. The other thing that happens in fingerprint evidence, and this is why it's so heavily criticized, is because when you look at a fingerprint, you roll your whole thumb, you roll your index finger, etc. Even when you go to the TSA pre-checkpoints or you do clear at the airport, when you do your fingerprints there, the machine is really capturing the entirety of your fingerprint. Rarely is it the case that a complete, pristine fingerprint is left at a scene. It is most often the case it's what's called a partial print. Well, while two fingerprints, meaning two completely rolled fingerprints, may be unique to each of us as humans, which that jury is still out, A partial fingerprint is not. So if I don't roll your thumb, but I have a partial thumbprint at the scene, well, how many people in the world have that partial thumbprint? The answer is, who knows? How does one examine a partial thumbprint for which they don't know the universe of folks that could have that and impute that to a single human being? Well, they employ testing, which is extremely subjective. And the argument I always make is, if you can have good eyesight, you could be an expert, right? Because you're just looking at Exhibit A, which is the print lifted from the scene, and Exhibit B, the print lifted from the accused, and you're saying, yeah, it looks pretty good. And they use these dots and they use these different things, all of which go to validate the overall opinion that, well, they're the same person. And fingerprint evidence is the one place where there's no error rate. And this is why it's so heavily criticized. So in DNA, you hear all the time, well, it's 1 in a trillion, 1 in a quintillion. The numbers now in DNA evidence, because of the technology, are astronomical. They're in the quintillions, quadrillions, whatever they are. In fingerprint evidence, what is the likelihood of the error rate? What is the likelihood that this print doesn't belong to this person? Oh, we have no idea. We either say they're the same or they're not.
And it's still subjective. It's still somebody making a determination.
Very subjective.
And when you're talking about a parking ticket, that's one thing. When you're talking about somebody spending the rest of their life in prison, it's obviously different stakes, right?
For sure. And I have had jurors come to me at the end of a case and said, you know what, we were 100% convinced the fingerprint evidence was trash because of this inconsistency, the absence of error rates. And then one fingerprint analyst in our lab here uses these dots. Another fingerprint analyst in the same lab uses a measuring stick to determine the length of distance between the whorls, et cetera, in one's finger. Even in our own crime lab, there is inconsistency in terms of how the test is done to measure whether or not the points of comparison are legitimate on a fingerprint, all of which culminates in something that, in my view, is not extremely reliable. That's not, so when you hear fingerprint evidence, that's the other thing. People know, well, if you have clear, you get in and out with your fingerprint, right? Well, yes, but you rolled your whole print to get clear. Then when you put your thumb on the instrument or the device that reads your print, you are again pressing your entire thumb. So the entire rolled thumb versus you now depressing on the machine, your whole thumb, that's one thing. Your whole thumb being rolled versus 18% of your thumb, or 33% of your thumb, whatever it is, that's a completely different ballgame. And while the PCAST report, which is now going on 10 years old, while it did not exclude fingerprints or tool mark evidence, which is, look at the casing, look at the mark made by the gun on the bullet that was fired. Does it look the same or does it not? Those two are on the chopping block. And like I said, that was 10 years ago. Those are still being asserted in courtrooms today. But those are likely the next ones that are going to drop.
And you can use, obviously you're going to use that when you're a criminal defense attorney to create reasonable doubt that, because they will, of course, prosecution will present it as it's fact, it's indisputable, but you have to find all of those little areas where you can come in and say, well, no, it's fact, maybe 20 years ago, but as you mentioned, things change. And talking about jury trials, because that's another something that you see a lot in true crime, the drama of the jury, sequestered and doing all that. Picking jurors, that's obviously a very specific skill. Do you use people that work with you to help you pick jurors? Do you use psychologists? Or?
Sometimes we do. Sometimes we don't, depending on what the call of the case is. So just every lawyer's different, and there's no right or wrong answer. I have personally done, I stopped counting at 125, but more than 125 jury trials. In the beginning, I used consultants much more often. What I do now is I rely on the experience that I've had where I can understand information that I'm receiving and calculate myself, which juror might be fair and impartial and which juror might have a predisposition. Also, we live in a world today where so much about human beings is readily available. So today, for example, we can do things that weren't available 20 years ago. So we get the jury list from the jury commissioner, and any competent, capable trial lawyer is going to get a copy of that list, get it to their office so that their team can immediately go on Instagram, Facebook, Twitter, whatever it is, and amass information about each of the people sitting in front of you. So in today's world, you can have Facebook and be private. You can have Instagram and be private. But people accept followers all the time from unknown folks, and, they're trying to build up how many followers they have, and they're trying to build up how many likes they have, et cetera, et cetera. And so we deploy devices through which we can amass information. And a recent example I had, we ask, for example, which political party do you associate with, right? And that in Nevada is an optional question. So you could put nothing, you could just skip it, or you can put Democrat, Republican, Independent, whatever it is. So I had a person who very much was outspoken on the questionnaire about, how liberal she was and how she believed in the Constitution. I mean, it was really over the top. Turned out when I had the team run all her social media, it was over the top about the love and admiration she had for Donald Trump, who is clearly not a liberal and clearly not a Democrat, et cetera, et cetera. So I had what appeared to be two competing assertions by this prospective juror. So I had pointed this out to the judge so as not to embarrass this particular juror in front of everyone else. So he had a 5-minute, 10-minute hearing just with her, the judge, the prosecutor, and myself. And I just said, hey, listen, we cleared the name, we cleared the Facebook page, this is you, that sort of thing. Now you've told us about all these things, on the questionnaire. It seems like you've posted, in favor of the other political party. Is that true? Definitely not true. Definitely not true. Never did that and was very emphatic. So now I show her the things that have been downloaded from her Facebook page. And she paused and said, someone must have hacked into my account. And if that's not it, then my husband must have done it. And it got so bad. And I was thinking to myself, why are you trying so hard to be on this jury? What's the agenda? But it didn't get that far. The judge clearly saw very quickly that we had someone that wasn't being honest. And even though had nothing to do with the nuts and bolts of the case, you can't start from a proposition of someone being dishonest with you. So we do use jury consultants as time has gone on, and jury consultants were taught to read, does the person have a pocket protector, and do they have pens, and what's that mean? Do they have a flannel shirt on? Are they wearing cowboy boots? What sort of belt did they have? If they carried a book into the jury selection room, what does that mean? What's the name of the book? What's the book about?
Right.
All those things now, we can see them with our own eyes. We don't have to guess at what those are. And if the person's material is not private, we can quickly determine on our own what they do and don't do. The jury consultants are still important from the perspective of the storytelling aspect of how we're going to frame the case. And those folks we do consult with how to best tell the story so that it resonates the best with the persons whose backgrounds are sitting in judgment of our client's case.
Yeah, and it's interesting because there's so much that goes into criminal law, obviously, and trying in front of a jury, because a lot of attorneys, and we talked about that before, when you first became an attorney, you started doing jury trials pretty much right out of the gate, and you were very successful. What's some things that you impart to younger attorneys that I know you've recently hired folks here, new folks, you're always adding new attorneys, but specifically dealing with jury trials, what's some advice that you give young attorneys and what to look out for, how to kind of navigate that?
Well, clearly you have to be very, very alert. So, I did this for a while, and it became sort of like a running joke. There's these video clips you can see online where there's a teacher in a classroom and they're talking about whatever, and the distraction's created, and then someone that has a gorilla suit on goes from the entrance to the exit, right? Did you notice the person dressed as a gorilla? Right. And so I use that as an example to force people to understand that they have to use all their powers of observation. Are persons, do they have their arms unfolded when they speak to the prosecutor? And then do they cross their arms when they're speaking to the defense attorney? That's probably not a good person for you, right? You have to see everything that you can see. And write things down. So juror number, 29 brought in a romance novel. Juror number 45 brought in, they had a pin on that said, Blue Lives Matter or Black Lives Matter. What does that mean, right? So you have to be observant enough to understand who you are speaking with. The other thing, and this I hammer every single day, anytime I know about a trial, a deposition, anytime you're going to communicate to somebody, lawyers are creatures of habit, and they like to write their questions down, and they want to make sure they've asked all the right stuff. And if you do that, then you're losing the art of the communicative skill that you should be deploying as a lawyer. And what I mean by that is this. I tell my lawyers, don't write the question down. Write down the answer. Because if you need the answer and it takes 4 or 5 questions to get there, it's okay. If you just write down the question and the answer, well, what happens if they don't give you exactly what you want? Then what do you do? So, number one, don't be mechanical about the process. Understand that you're having a conversation with a juror, with a witness, with a court, whatever it is. So as much as you are watching, you must listen. So the other thing I tell the younger lawyers here all the time is listen to what the answer is. Do not read the next thing on your piece of paper. So what time was it when you were at the party together? If the lawyer writes down 10 p.m. and the witness answers, wait, what party are you talking about? Okay, you have to, and I know this is very basic, but this happens all the time, but you have to be able to say, I'm talking about a party that happened that was where you met so-and-so or you saw my client or whatever it was.
Yeah, you have to be in the moment.
You got it. That's right. You got to be in the moment. And you'd be surprised how many attorneys place much more emphasis on the mechanics of being a lawyer as opposed to the art of being the lawyer. And so I try to emphasize the art of being a lawyer, which is the magnification of our different sensory perceptions. Look at everything that's going on. Watch the people as they walk in. I've had jurors show up with suits and ties on, all done up. I've had jurors show up in sweatpants that look like they haven't had a bed to sleep in 3 days. What is the messaging there, right? If someone shows up unkempt, they don't care, they're slouching back in the chair, they just want this to be done as quickly as possible. Is that a good juror for you in your case, or is it a bad juror? If you have someone that comes in and is dressed up in a suit and tie, everyone knows at least they took it seriously, right? And so they're going to be attentive. They're going to be in it for the duration. Do you want that kind of juror or do you not? But if you don't look at those things, if you don't look at those details, you've already lost.
Do you talking about art, and in a way it's performance when you're a criminal attorney. doing it during a jury case in front of a jury, in front of a judge. And you have a performing background. You're a musician. You've done that all your life. Did you find like that in a way that actually helped you? It helps you because you have to learn how to read the audience. You have to learn how to read people and pay attention, right?
Yeah, well, there's no doubt about it. First of all, performing as a musician helps a ton because you get over the butterflies of being in front of people and speaking to them about whatever topic it is. You gain this confidence that allows you to pronounce what your cause is, to advocate a certain way, and one feeds in the other. Being in front of people as a lawyer, I think, helps me be on stage when I'm just playing guitar, and vice versa. And playing guitar helps me when I'm in front of a jury because it allows for the guard to be down. You don't appear nervous and anxious. I can just have a conversation with somebody. The other thing that the music stuff helped me with a ton was I never got to that place where I felt like, or jurors felt like, I was speaking as a lawyer and holding myself up at a particular level, and I never was accused of speaking down to anybody. Being in bands forces you to work with all sorts of people, and there is always a common baseline upon which you can build your communications, and that translates 100% into a jury trial. I have had literally brain surgeons as potential jurors. I have had auto mechanics, school teachers, persons who are unemployed, students at UNLV, college professors, the range of blackjack dealers, the range of individuals that have been potential jurors has run the gamut. And so you cannot begin with an approach that causes you to be perceived as placing yourself in a category above anybody else. You've got to be in it with everyone at the same time, and that's what causes your story to be accepted and believed. And so when we're doing jury selection, I talk about all kinds of things. I had a juror one time that I was able to connect with because she said she wrote songs. So, of course, well, what kind of songs do you do? Oh, I do indie and some emo. Well, I know what both of those things mean. So we talked about indie. How was it? How did she find it? Was it something that she was struggling with? And how does one go from indie, which is more of storytelling, to emo, which is more happy and peppy? Now, the fact that she realized that I could relate to her, even though I was much older than she was, it created this thing where, okay, well, maybe I can trust this guy because he's able to communicate with me in a way that I understand. And so at the end of all of it, when we have the jurors that are there, so maybe I have someone who is a songwriter, I have someone who's a school teacher. School teacher, I always ask, okay, I say this all the time. I have kids. You have kids at your class. Someone comes and says, they took the candy from the candy jar. My other kid says, no, it was her, it wasn't me. How do you reconcile that conflict? So what have I just now revealed? I'm a dad too. This thing happened, whatever's going on impacts me as a parent, just like you. I deal with kids. You deal with kids. So what we're trying to do is we're trying to create this community of individuals that are complete strangers with one another. And I want them to embrace me as part of their community.
Yeah, and it's a big part of that is establishing credibility and them respecting you because they have to believe you. If they don't believe you, then you've already lost. In a way, you've already lost the case, I would imagine.
Yeah, for sure. They have to believe you, but they also have to relate to you, and they don't want to be, the folks that you think are different or lesser or whatever it is. And to be honest, there have been many jurors, prospective jurors, that are far more educated than I am. And there are folks that have jobs with the Department of Defense and the Justice Department that they're housed or they're located in Las Vegas. They have far more pedigree than I do. They have a higher level of understanding. Their vocabulary is better than mine. They do much more sophisticated work than I do. And I have to be able to figure out how am I going to speak to those folks, right? The same way I do have to figure out someone who maybe is a, I don't know, an out of work auto mechanic.
Right.
The auto mechanic, the person splitting the atom, and myself, we all got to figure out what that common ground
And
is.
different ethnic backgrounds, obviously.
Sure.
Yeah, there's a lot at play. And that's the really fascinating part about what you do, because you're navigating all these different things at the same time, trying to establish credibility, trying to have them believe you, because if they don't believe you, then you've kind of already lost in a way, kind of getting over that challenge. Tony, tell people how they can contact you and interact if they'd like to.
Sure. You can reach me at tsgro@sgroandroger.com, Sgro and Roger website, or our office number at 702-384-9800.
Yeah, and please make sure to like and subscribe for future episodes. We have a lot of fun stuff coming, and lots of plans to cover a lot of different topics. And if you have a question or a topic you'd like us to cover, please feel free to email us.
All right. Thanks so much.
All right. Have a great day, guys.
Thank you so much for joining us, and for further information, please visit our website at scroandroger.com. Please like and subscribe.